You're getting great experience, Miss Herring.
Yeah.
Judge Gardner, it looks like Officer Wright, can you hear me?
Yes, ma'am. Can you hear me?
I can. It looks like Officer Wright has logged on, Judge.
Okay. I've hit the live button for this to go live on YouTube. I'm calling the case of State of Georgia versus D'Angelo Mallet. He's charged in warrant number 2021 CW 53603 with committing the offense of theft by taking. Ms. Pitts, you have the floor.
Thank you. Officer Wright, would you please raise your right hand? Do you solemnly swear and affirm that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
Okay, put your hand down. State your name.
I am Officer Torian Wright.
And Officer Wright, where are you employed?
I'm currently employed at Clayton County Police Department.
And what is your job with Clayton County Police Department?
I am a uniform patrol officer.
And essentially and efficiently tell me what a uniform patrol officer for Clayton County's responsibilities are.
My responsibility is to enforce the law of Georgia and to patrol the streets, make sure everybody is safe, protecting the community.
And do you respond to 911 calls?
Yes, ma'am.
On July 9th of 2021, were you working in your official capacity
Yes, ma'am.
as a patrol officer for the Clayton County Police Department?
Yes, ma'am.
And at that time, Officer Wright, were you post certified?
Yes, ma'am.
All right. Did you respond to a theft call at 6370 Route 217 Old Dixie Road in Jonesboro?
Yes, ma'am.
And is that incident location within Clayton County?
Yes, ma'am.
Will you please tell the court what you were responding to and what happened once you responded?
Okay. I was responding to a theft call, and Mr. Nesbitt, he called in regards to his backpack being stolen from his room.
Okay,
He said, okay.
go ahead. Was that it? Were you going to go further, or did you want me to follow up with questions?
That was pretty much the gist of it.
Okay, all right. And did Mr. Nesbitt have any idea who had stolen his items?
Yes, ma'am.
And did he identify that person to you?
Yes, ma'am.
Did he identify that person as Millette D'Angelo McWelly
Yes, ma'am.
or D'Angelo McWelly Mallet?
No, he introduced him as D'Angelo Mallet.
Okay. And how did Mr. Nesbitt know Mr. Mallet?
Well, Mr. Nesbitt knew Mr. Mallet because they were friends, and he just allowed him to stay in the room for a couple of nights.
Okay. And so that Old Dixie Road address, what is at that address?
What is at that address?
Right. Is it a hotel?
Yes, it's a hotel.
Okay.
Yeah, it's a hotel.
And during your investigation, did you learn that Mr. Nesbitt had a room at that hotel?
Yes, ma'am.
Okay. And did he inform you that Mr. Mallet had stayed with him the previous evening?
Yes, ma'am.
What, if anything, did he tell you as it pertains to his items and Mr. Mallet?
He said he left Mr. Mallet in the room when he went to go find some parts for his motorcycle. And he said he left with a black backpack. And what was in the items was a laptop, motorcycle jacket, a motorcycle test kit, and his money. And he said when he got back, the backpack was gone. However, the offender left all of his stuff, dirty clothes in the room, which I saw. It was a lot of dirty clothes in the room. but that backpack was not there.
Okay. And so based on what Mr. Nesbitt was telling you, did you do any further investigation? For example, did you view a video?
Yes, ma'am.
And was that video provided by the hotel?
Yes, ma'am.
Did that video corroborate what Mr. Nesbitt told you happened?
Yes, ma'am.
Will you tell the court what you saw?
What I saw on the video was Mr. Nesbitt, he opened the door initially. Then he looked out to see if the victim was possibly in the parking lot. I don't know exactly what he was looking out the door for, but he left it open. So
And I'm going to stop you. You said, I'm sorry, I didn't mean to interrupt you. You said Mr. Nesbitt looked out the door.
Oh, no. Not Mr. Nesbitt. I meant the suspect. Yeah, the suspect. He looked out the door. I don't know what he was looking at, but he kind of went out the door looking to see if anybody was around, I guess. But then he went back in, and then I seen him come out with a black backpack, and he left the door open. And then I could see him walk across the crosswalk, down the stairs, and get into a vehicle, but I wasn't able to get a good picture of the vehicle due to how far it was away from him.
And did the description of Mr. Mallett given to you by Mr. Nesbitt match the individual that you saw in the video?
Yes, ma'am.
Okay, Officer Wright, can you see the defendant in this video, in this Zoom call?
Hold on, let me find it. I did initially. I don't know.
Okay. And initially in the Zoom call, the individual you saw, is that the person that was identified to you as Mr. Mallett?
Yes, ma'am.
And is that the person you took the warrants out on?
Yes, ma'am.
As part of your investigation, did you receive any additional information that corroborated what Mr. Nesbitt said occurred with his property? For example, did you view or see any text messages?
Yes, ma'am.
And can you tell the court what text messages you saw, who they were from, who they were to, and the gist of the content?
So the text messages were from somebody named, he saved in his phone as D'Angelo or D. And he said basically that he did have the stuff, and he said he wasn't planning on giving it back.
Okay. And based on your investigation, did that corroborate what Mr. Nesbitt reported to you?
Yes, ma'am.
After that, what, if anything, did you do? Or after that, did you in fact take out warrants against Mr. Mallett?
Yes, ma'am.
Okay. And since then, have you learned about information pertaining to Mr. Mallett's arrest?
Yes, ma'am.
Did you learn that Mr. Mallett was arrested by another officer that was investigating a robbery?
Yes, ma'am.
And during that arrest, that the defendant gave a false name. He actually used his brother's name. Were you made aware of that?
Yes, ma'am.
Okay. And that the
relevance?
it's intrinsic to the case that he is here for now.
I had a hearing yesterday, Ms. Pitts, on the giving a false name charge, and it was bound over to state court. So I'm gonna sustain the objection as it relates to the giving a false name information.
I understand. And Your Honor, just insofar as I wasn't a part of that, I don't know what the record reflects. And I do want the court to have a clear understanding when you are considering binding this over and when you make the consideration of binding this case over.
I agree with you on that, Ms. Pitts. I don't understand how these cases get parceled out to different courts, but I've already made a determination that there is probable cause on the giving a false name.
I understand. I have no further questions about the false name, just about the defendant's knowledge and going forward on the warrants that Officer Wright took.
Okay.
So that was the only question I had about the false name. Officer Wright, were you also made aware that during his arrest at that subsequent robbery incident that he admitted that he knew that he had outstanding warrants.
Yes, ma'am.
And that would have been a warrant that you took out in this theft by taking case. Is that correct?
Yes, sir.
And to be certain, the amount of the items that were taken from Mr. Nesbitt exceed $1,500 based on your investigation. Is that accurate?
Yes, ma'am. Yes, ma'am.
And were you also, the incident date, your incident date occurred July 9th of 2021, is that correct?
Yes, ma'am.
And did you learn that Mr. Mallett was not arrested until December 29th of 2021?
Yes.
Thank you, Your Honor. I have nothing further.
Ms. Herring?
Thank you, Your Honor. I'm sorry, officer. What, can you state your name again, please?
My name is Officer Torian Wright.
Right. Okay, Officer Wright. I apologize. You advised you viewed video at the hotel.
Yes, ma'am.
Were there multiple angles or just one angle viewed?
It was multiple angles.
How many?
It was like 2 angles.
Okay.
One
And
directly at the door and one on the side of it.
okay. And what time did Mr. Mallett leave based on what you viewed?
What time he left? I'm unsure due to the amount of time that's passed from me seeing the video.
Okay. Did Mr. Nesbitt advise how long he was gone from the hotel room?
He advised he was gone about 30 to 45 minutes.
Did Mr. Mallett return to the location at any point during your investigation?
No, ma'am.
How long were you on scene?
I was on scene for an hour.
You said, I'm sorry, what time?
I was on scene for about an hour.
Okay, what time did you arrive?
I had arrived around the beginning of my shift. So it was around 4 o'clock.
4 p.m.?
Yes, around
Okay.
4 o'clock.
All right. And when Mr. Nesbitt advised you of what was taken, did he give any distinguishing features of the backpack?
He said it was a black backpack. He didn't give me any type of brand.
Okay. And what was Mr. Mallett holding on the video you saw?
A black backpack.
Were there any distinguishing features on the backpack you viewed in the video?
No, by how exactly how far away the camera was, you couldn't see the brand of backpack it was.
Okay. And Mr. Nesbitt confirmed that Mr. Mallett was an overnight guest at his hotel room?
Yes, ma'am.
Did he advise whether or not he had any luggage with him?
He said he had some clothes that he brought in every now and then.
Did he say what the clothes were stored in?
No, ma'am.
Did he say whether or not Mr. Mallett also had a backpack?
No.
Did you speak to Mr. Mallett at any point during your investigation?
No, ma'am. I attempted to try to call the number that was associated under the license. And I also called the phone number that was on his phone, but I never received the answer.
So you contacted what phone number? The one from the license, and what was the second phone number?
I am unsure.
I'm sorry, so I'm
Hold on. Give me a second. Hold on. Give me a second. Okay, I contacted the 678 number, 933-6786.
And how did you obtain that phone number?
I obtained the phone number from Mr. Nesbitt's phone, from which I seen the text message.
Okay, so you were not able to get an answer at that phone number?
No, ma'am.
So you didn't speak to anyone at that number?
No, ma'am.
How did you confirm that was Mr. Mallett's phone number?
because when I did my investigation, so the nickname that was under the phone was also one of the nicknames that was used um, on Facebook. And on Facebook, it showed his full name and his date of birth. And that's how I was able to actually get the rest of the information that kind of came together.
I'm sorry, you obtained his Facebook. How?
I just searched his name on Facebook.
Okay. And your statement is you located his page based on a name and date of birth?
Yes, ma'am.
How did
Give it
you
to me by Mr. Nesbitt.
I'm sorry?
Give it to me by the victim.
Okay, but you did not make contact with Mr. Mallet to confirm
No,
that, correct?
no, ma'am. I tried, and I never made contact.
Okay, so your methods of contact, to be certain, you contacted a phone number associated with his driver's license, correct? And there was no answer. The phone number that the victim provided, there was also no answer.
Mhm.
Did you speak to Mr. Mallet at any point during your investigation?
No, ma'am.
Okay. All right. How did Mr. Nesbitt assess what he alleges was taken?
He pretty much looked what was in what was in his backpack, because he stated he went to the vehicle parts store to get more parts. However, when he came back, he realized his motorcycle tools were gone because he wanted to fix his motorcycle. And then he said they were in his backpack, but also his backpack was gone. And then that's when he realized his laptop was gone. He left the laptop at his back.
Okay, so what items did Mr. Nesbitt allege were taken?
His motorcycle jacket, his motorcycle tools, his money, and his laptop.
You said you went to the hotel room?
Yes, ma'am.
What was the state of the room?
The state of the room, it was clothes thrown on one of the beds. It really wasn't much. It looked like somebody lived in the room. It looked like multiple people lived.
Were things organized? Was there luggage?
Oh, there wasn't really luggage. There was a duffel bag, and then it was clothes thrown everywhere on the bed, and it was a couple on the floor, but it wasn't completely organized, but it was in complete disarray.
Okay, so the room was in disarray. Did Mr. Nesbitt advise whether or not he looked for these items before he contacted the police?
Yes, it was some time. He looked for them before he called the police, because he looked through the room to make sure.
Was there anyone else staying in the room with Mr. Nesbitt?
No, ma'am.
Did he advise how many keys he obtained when he rented the room?
No, ma'am.
Okay. All right. Did he advise whether Mr. Mallet had a key to the room?
Yes, ma'am. He said he didn't have a key because he let him in.
How long did he say Mr. Mallet was staying with him?
He said Mr. Mallet was only staying with him for the night. He said he only let him stay over for the night.
Did he indicate that Mr. Mallet was supposed to leave on the day of the incident?
No, ma'am, because he said he left him sleeping. He said he left him sleeping in the hotel room while he went to go get parts.
So was he expecting Mr. Mallet to take his things and leave on that day?
Your
No,
Honor,
ma'am.
I'm gonna object to that question. That requires the officer to speculate as to what Mr. Nesbitt assumed Mr. Mallet was doing.
To the extent that the officer has knowledge and can respond to that question, I will let him respond. But if he does not know, he does not know.
Just to be clear, Judge, I'm a she.
I'm sorry, sir.
I'm a she.
She. Oh, I'm sorry, ma'am. I am so sorry.
It's okay. It's a haircut.
Miss Herring, would you restate the question?
Actually, I'll retract that question, Your Honor. That's fine.
Okay.
So Mr. Nesbitt confirmed that Mr. Mallett still had belongings in the room when you arrived, correct?
Yes, ma'am.
Okay. Generally, did he assume that those clothes were discarded?
Your Honor, I'm going to object. I don't know that that goes to the whether or not the defendant, if there's probable cause as to whether or not the defendant took the victim's items or not, and it does call for speculation.
Ms. Herring?
I'll retract the question, Your Honor.
Okay.
Okay. At this point, you observed Mr. Mallett's clothing in the hotel room, correct?
Yes, ma'am.
Okay. Were they placed in any kind of trash receptacle?
No, ma'am.
Okay. Did they look to be discarded?
No, ma'am. They were just kind of thrown all over the bed.
Okay. All right. Did Mr. Nesbitt advise how he knows Mr. Mallett?
He didn't say exactly, but he said he's known him for a few months, and that since he didn't currently have anywhere to live, he would just let him stay in the room for the night.
Okay. Did he tell Mr. Mallett that he had to vacate the premises that day prior to leaving to run his errands?
No, ma'am, he did not mention that.
Did he make any statement to you that Mr. Mallett no longer had any authority to be in the room?
No, ma'am.
Okay.
He never mentioned
All right.
that.
Those are all my questions, Your Honor.
Any redirect, Ms. Pitts?
Your Honor, briefly, the text messages that you observed, that you stated came under the name of D'Angelo, were they consistent with Mr. Mallett having the items that Mr. Nesbitt identified to you?
Yes, ma'am. He was fully aware of the items he took, and he was not planning on giving them back.
And there was an affirmative statement that he had them and he was not going to return them. Is that correct?
Yes, ma'am.
Nothing further, Judge.
Any recross?
No, Your Honor.
May Officer Wright be excused?
Yes, Your Honor.
Officer Wright, you're excused. Thank you for your presence today. You can stay on if you like. Any argument?
Okay.
Your Honor, state will reserve.
Okay. Ms. Herring?
Yes, Your Honor. The testimony by Officer Wright shows that Mr. Mallett had belongings in the room. He was allowed to be there. He was staying overnight with Mr. Nesbitt's permission. There are no distinguishing features given for the backpack to verify whether or not the backpack that Mr. Mallett possibly was viewed on video belongs to either Mr. Nesbitt or Mr. Mallett. There was no confirmation that Mr. Mallett does not also own a black backpack with no distinguishing features. Also, there was no testimony that Mr. Mallett had a key to the hotel room. Officer Wright also testified that he left the door open. All these facts together show that, on the one hand, Mr. Mallett did not have the intent to deprive Mr. Nesbitt of his property. He was placed in a situation where taking the property was a necessity. The door was open. He needed to leave, and at that point, he was doing his best to secure Mr. Nesbitt's property. So any property he may have allegedly taken he did not take with the intent to deprive Mr. Nesbitt. Mr. Nesbitt did not advise that he had no permission to take anything. He was in the room with permission. And if there's no intent at the time that any property is taken, no larceny has been committed. The OCGA 16810 provides that in the event that our client had reasonable belief that Mr. Nesbitt would have provided consent to hold any particular items because of the potential for theft with a hotel room with an open door, he would have an affirmative defense there. So at this point, we request dismissal because there's no intent proved based on Officer Wright's testimony. Mr. Mallett was freely in the room. There's no indication that he took any property of Mr. Nesbitt, but in the event that he did, he's under reasonable belief that Mr. Nesbitt would have consented to that, given the fact that there was no way for him to secure the hotel room without a key.
Let me push back a little bit on that argument. Let's see. It looks like the warrant was issued on July 26, 2021. And Mr. Mallett was arrested on December 29th of 2021. Is there any evidence that you're aware of that the items that Mr. Mallett was attempting to secure for Mr. Nesbitt, whether those items were returned to Mr. Nesbitt?
That's the statement I've received, Your Honor. I don't have any information, any objective information, independent information of that. I haven't spoken with the victim.
So your argument that Mr. Mallett may have been holding these items to secure them on Mr. Nesbitt's behalf, you don't have any evidence to support that argument?
I have that's an alternate argument, Your Honor. I mean, our argument is that there was no larceny. Mr. Mallett didn't have any intent to take any property, to deprive Mr. Nesbitt of any property. At this stage, I don't believe that there's sufficient basis to prove that Mr. Mallett took anything at all that belongs to Mr. Nesbitt.
But for Mr. Nesbitt saying that when I left the room, these items were in the room. When I came back, Mr. Mallett was gone and my items were gone.
Right. That was prior to Mr. Mallett also returning to the room.
Returning to the room?
Right. Mr. Mallett returned to the hotel room.
Your Honor, I'm going to object at this juncture. The counsel is testifying. I don't believe there's any evidence before this court to those facts.
And I was saying, if I missed it, I missed it, but I didn't hear any testimony that Mr. Mallett returned to the room.
Okay, I retract that statement, Your Honor.
Okay, Ms. Pitts.
Your Honor, I believe intent is clearly stated here. As the court pointed out, this incident occurred on July 9th of 2021, and the defendant was not arrested until December of 2021. There's no evidence before this court that the victim items were returned, or that the text messages that the officer observed and took photos of with her body cam were inconsistent with what Mr. Nesbitt reported to officers. The officer herself stated that she was on scene for in excess of an hour, and the messages that she observed made it clear that Mr. Mallett took the items, was in possession of the items, and had no intent on returning the items. The conversation alone can indicate that Mr. Nesbitt never gave the defendant any consent or permission to be in possession of his items. Your Honor, the fact that counsel is making an argument that he took the items to keep them safe because he couldn't close the hotel room door, I don't believe is believable. The defendant's taking of the property, I believe she argued, was necessary. And additionally, Your Honor, at this juncture, an affirmative defense would not be something that the court should consider. So for all of those factors, Your Honor, the amount of the items has been established that this was a felony amount. The video that was viewed by this officer and the only evidence before the court is that he left with the bag that was described by the victim in this case. There is zero evidence that the defendant himself also had a bag. I believe those are just remarks that counsel made, but there is zero evidence in the record for the court to make that consideration. And so for all of those reasons, Your Honor, the state would ask that you would bind this case over. The state would also ask the court to consider the bond on Mr. Mallett in this case and his current circumstances. The defendant has 2 open felony cases in the Superior Court, one for armed robbery and possession of marijuana, and that is assigned to Judge Carter, and another from 2021 for robbery that is currently assigned to Judge Scott. At some point, we will get all of those. This theft by taking over. This defendant appears to be a serious risk of reoffending, and that is established in his open history. I won't go into any other history, and therefore, my understanding is the bond in this case is set at $5,000. I would ask the court to increase it to $15,000.
So let's take it in order. I'm going to find that the evidence is sufficient to bound this case over to the Superior Court of Clayton County on the felony count of theft by taking. My general approach, Ms. Pitts, is that bond is something that is, I think it was the Salerno case out of federal court, that liberty is the norm and bond should be the carefully crafted issue to make certain that the person returns to court. So I don't view bond as being punitive. I understand the state's position and how different that could be. But Mr. Mallett has not been able to make the bond that he has. So I'm not going to increase the bond amount for Mr. Mallett. I do understand your statement and your argument as it relates to, as a judge, I'm concerned about the protection of citizens within this county. And it's my duty to make certain that I keep the citizens safe. For this type of offense, it's not something that I'm going to view as I have to set a bond that is so high that Mr. Mallett can't make it. So that's my reasoning, and I'm going to deny that request.
Understood. Thank you, Judge.
Okay. Mr. Mallett can be returned back. So what I have left is Mr. Spain.
Thank you, Your Honor.
Thank you, Ms. Herring.
Just give me a minute. I just got his contact. I'm gonna see if he answers the phone. Mr. Schoolcraft.
Okay.
Thank you, Officer Wright. You can be excused. Thank you.
Thank you.
Mr. Rogers, are you there?
So,
Ms. Pitts, you indicated that there is some additional information that you wanted to make the court aware of.
Correct, Your Honor. First, I did want to reiterate to the court that the officer, Brian Gator, is in training. And he did report to us that he would be in training from 2/7 to 2/11. So therefore he's unavailable. And the state was asking for a continuance to allow that officer to come and testify in this particular case. I understand that the court was going to consider counsel's request to dismiss. However, I did want the court to have some information in reference to Mr. Spain. In this particular case, it does involve a victim. The defendant has a extensive criminal history, both in Georgia and in South Carolina. His history dates back to 2004, but if we were to look just in the last 10 or 11 years, he has a conviction for forgery in the first degree. He has a possession of methamphetamine conviction, and he has a possession of meth conviction in 2020. He is currently on open probation out of Clayton County. He just took a plea in Judge Malone's courtroom.
When was that?
That plea was entered on 12/29 of 2021. Is that right? Hold on. No, that's incorrect. I'm sorry. That's the date of this. I apologize. Give me 1 second. This is the victim witness file. This is okay. Give me 1 second, Judge. This is 2019. That offense date was August 1st of 2019. He was sentenced to 4 years to serve 1 year with the remainder on probation and to complete 100 hours of community service. And that was effective July 15th of 2020. So he would have, if we were to count day for day, he would have gotten out at or around July of 2021, and he would still have 3 years of open probation. So he is therefore on probation, and that was for possession of methamphetamine. He pled to drugs not in original container, 2 counts in open container, improper backing, and failure to carry a license. I will also tell the court that Mr. Spain has, in 2018, a charge for fugitive from justice. So the state's concerns, Your Honor, are that Mr. Spain has current open probation. He has an extensive criminal history. He has shown in his history that he will not make himself available for the court. And he has a fraudulent check conviction out of South Carolina in 2010 and a disorderly conduct out of South Carolina in 2014. Again, which raises the state's concerns about the defendant's amenability to be available for the court. So for those reasons, Your Honor, the state would ask that when you are considering not allowing a continuance because an officer is in training, that you would take into account that this particular individual has shown that he will not be available for court, and that there is a large likelihood that he will commit felonies pending this case proceeding and that he is on open probation. I am not certain if probation has had an opportunity to actually do a warrant, but obviously at the conclusion of this calendar, the state will be making probation aware that a petition should be filed and served on Mr. Spain.
Mr. Rogers,
Yes, sir.
it looks like I did the first appearance. I'm looking at the criminal history, and I see the arrest. And it looks as though your client was found guilty. Looks like case number 20 CR 00889 for possession of methamphetamine drugs not in the original container. But if that's the case, your client wouldn't be eligible for bond under 1710-1.
Well, I'm not. That's I would say I would largely agree that it's kind of all irrelevant. That would be my position. That everything the state just said is irrelevant because it's not a bond hearing. What I've asked for is a dismissal for warrant of prosecution. It doesn't matter. He still has the same rights, and the state still has the same obligations. I don't care if he has a record from here to Timbuktu. It does not excuse the state of his obligations, and it does not deprive him of his rights. Furthermore, after everything the state said about how concerned they are about this and about that, it would seem to me that as he was arrested in December, looks like, and I'm looking at the calendar that I have access to, it seems to show that there was subpoenas sitting around December the 30th. What they did not tell you is when did the officer file this notice? When did he get notice of the training? Like, that's where the focus should be. They're trying to shift the burden to say that Mr. Spain is supposed to be some sort of angel to have rights or for the state to be held to any kind of standard. That's not the case at all. So everything they just said would be relevant at a bond hearing. Everything they just said would be relevant for a reason for them to make preparations if they're so concerned about his case being dismissed to have had their officer here. It's not a reason to deprive him of their rights or to excuse them of their burdens. So everything she said, completely irrelevant to the issue in hand, which is a dismissal for warrant of prosecution. This is not a bond hearing. So all the things she said, those are factors for a bond hearing. This is not that. So what she said, completely irrelevant. Don't say anything. His charges, all of this stuff, irrelevant. The state, if they were that concerned, should have had their officer here. Since they made such a big hullabaloo about how concerned they are, should have had the officer here. It's just that simple. It's not complicated. They've had, approximately a month and some change. As of December the 30th is when, like I said, the subpoenas that I'm seeing is showing as email. And additionally, I'm not sure what authority the state has to say that an officer's training trumps either the court date, the defendant's rights, or any of these things. So again, I would say everything that the state has said is completely irrelevant. The issue is they don't have their witness. They didn't make the preparation that they should have to have their witness present. Thus, they are not ready. Thus, I would move for dismissal for warrant of prosecution.
So, Mr. Rogers, you do understand that it's within the court's discretion.
Yeah, I didn't hear the last part.
Oh, that it's within the court's discretion as it relates to whether to grant a continuance or not.
Yes, sir. I do fully understand that. I would also point out that the state has just said that they intend to, I guess, get around to seeking a probation warrant or something at that point. If that's the case and they're concerned about it, the concerns that they've just raised that they're so concerned about will be addressed by that. So, I mean, they seem to have presented a problem and a solution.
Your Honor, the state would argue that a right to confrontation does not attach to a preliminary hearing. The court is allowed to take into account hearsay as well as the arrest warrant and find that there's probable cause based on that. So what counsel is arguing is we're not at that standard. And so the court can make a decision based on the documents and make a finding at this juncture. However, the state is asking for a opportunity to get a witness in if that is what the court is inclined to do. And in that interim, the state is giving the court the information as it pertains to this particular individual. I don't believe it's irrelevant. I think that a preliminary hearing and the court's decision is based on the totality of the circumstances. And the totality of Mr. Spain's circumstances is that he is a risk.
And I would just point out that the totality of circumstances applies to a finding of probable cause, not to, and the totality of circumstances doesn't include, has this person ever been arrested before? That doesn't indicate whether or not there's probable cause to support a charge. Additionally, there has to be some sort of evidence offered. The state does not have a way to offer evidence at this point.
So generally, Ms. Rogers, I take these matters seriously, and I weigh basically the request from the state for a continuance against what I believe to be my duty as it relates to public safety. So on days of dealing with misdemeanors, is heavily weighted against the state. When you're dealing with felony charges, it's not heavily weighted against the state as it relates to what I'm dealing with, but there is a concern about the rights of the accused. In this particular case, I think I am more inclined to give a short continuance to the state. Miss Mary, who's doing the preliminary hearings next week?
Hold on, let me check.
Looks like it may be Judge George.
It is.
Okay. Mr. Rogers, I'm inclined to deny your request for a dismissal for warrant of prosecution. But let's see if we can get this on either the 14th or the 16th. Miss Mary, do you believe you can do that?
No.
You can't.
Mm-mm.
When's the earliest we can get Mr. Spain back on the calendar?
I can try and get him on the 21st calendar.
Looks like it's going to be Judge Case Johnson.
Unless you want to reach out to Judge George and see.
Well, let's put it on the 21st.
Okay.
Okay, I see we have Mr. Schoolcraft here. Mr. Spain can be sent back. Mr. Schoolcraft,
Yes,
how are
Your
you
Honor, I
doing, sir?
apologize. I'm doing okay. I was in another court in doing the same thing in Henry County this morning, so I apologize.
I understand that you were possibly wanting a continuance for Miss Bell.
Yes, Your Honor, I found out about Miss Bell a couple days ago. I haven't even entered an appearance yet. And I'm fairly new at what I'm at my job at this particular position, not at what I do. I've been doing this for a long time. But I'm fairly new and I'm just getting acclimated. I understand there was a case on Monday too, which I didn't know anything about. So I'm just trying to get my feet wet, get acclimated, and I just need a little bit of time. And I apologize for any inconvenience to the court.
I think it was it Monday or was it Tuesday? It may have been Monday. So Ms. Pitts, I understand the state doesn't have an objection to this.
No, Your Honor, no objection from the state.
Miss Mary, can we place Miss Bell on the calendar for the 21st or the 23rd?
She's a co-defendant, Your Honor, with Mr. Spain. So it may be a little more efficient if they're on the same one. So if we can put her on the 21st.
Yeah, if
Yes,
she's a co-defendant, then I'll put her on the 21st.
Thank you. Thank you, Ms. Pitts, for that information. So, Mr. Schoolcraft, this case is going to be continued until February 21st.
Is that a Monday, Judge?
Yes, sir.
That's President's Day?
I
It is, Judge, but the courts are open.
I
Yeah, I was
understand
gonna-
that. I understand that.
I was gonna
Judge,
say
if
it.
I could, I'm supposed to be out of town that weekend. I was hoping that if we can do it on the 23rd, but since we just scheduled a co-defendant, it's going to be difficult.
Yeah, it's going to be difficult. Let's keep it on the 21st, Mr. Schoolcraft.
Okay.
Now it's by Zoom, so you can log in from wherever location you may be at that time.
That's true. Hadn't thought about that.
It's a whole new world. And I was going to say, as a magistrate judge, I don't even count holidays or anything because magistrate court is always open. So, so we're always working.
Is she has no bond at this particular point in time, Judge?
She has a $5,000 bond on the robbery by sudden snatching, $3,000 bond on false imprisonment, a $3,000 bond on simple battery, a $1,500 bond on use or possession of drug-related objects.
How much was that, Judge?
So let's see, 6, 5, 11. Looks like $12,500 is her total bond amount.
Okay. Okay. Was that set at a first appearance hearing, Judge?
Yes, sir.
Okay. Good enough. Thank you very much. I appreciate it. And again, I apologize for being late in getting in.
No, I'm glad we got you. Just send whatever information you have over to Miss Mary. And it's Mary.Moultrie, Moultrie, ULTRIE at ClaytonCountyGA.gov.
Judge, can we take us off